Is he good?
Oh, yeah, he's going to save Red Mountain.
Oh, wow.
I'm out of the middle of those fights now, Senator.
Let's see. You know, sometimes you fight hard for a community to get something, and I got the money through Vermont Housing and Conservation Trust for Red Mountain, and the select board decides, oh, we don't want to go through all this because a couple of neighbors complained. So I thought you'd fix that, but
I think it'll get fixed eventually after some conversations behind the scenes about that very point about how folks such as yourself work to secure support for that, right?
yeah, I mean, the funding was really, Gus Seeley, you got him to go to bat for it. Then to have the town say, no, we don't want this. We don't want those people hiking in our hills. Oh, well, I love Arlington still. Good morning. We're back live. And this bill is not in the Senate Judiciary Committee, so please don't anybody get confused. It is in the Senate Government Operations Committee, and we will be providing advice to the Government Operations Committee on only sections 1 and section 6 of the bill. Section 1 has to do with a study that would be done by the Justice Oversight Committee, and section 6 has to do with revising it. Had to do with should have gone there first. Section 6 has to do with sexual exploitation of a person under the supervision of the Department of Corrections. It was originally current law as an inmate, and this would apply now to probation and parole officers and others. So, with that, I'm going to turn it over to Commissioner Jim Baker of the department, interim Commissioner Baker, who's now been here longer than most commissioners in most states, but he still retains the title of interim.
I do.
And I merely point that out because, I'm sorry, Bryn Hare was the first, but
correct.
I think, Bryn, I don't know that there's much to walk through here.
It's up to the committee. I'm happy to talk about that section 6, the sexual exploitation piece, but if you don't feel like you need to walk through, that's your prerogative.
I suppose we probably should. But
okay.
Then I can reintroduce the commissioner.
Okay, sure. So, so I'm gonna talk to the committee about section 6, which is that sexual exploitation of a person under the supervision of DOC. And I can share my screen if you'd like to, so everyone can see the bill. Okay. All right, can everybody see that? Okay, so I'll just start with a little bit of history for the committee. There was a report issued in the end of December of last year from Downs Racklin Martin to the Agency of Human Services concerning the sexual misconduct allegations of the Chittenden Regional Correctional Facility. And one of the things that the report concluded was that our existing sexual misconduct statute that criminalizes this type of contact between DOC staff and supervisees is too narrow because, and this committee will probably remember this, it limits criminal conduct to sexual contact between DOC supervisees and DOC staff that are in a direct supervisory relationship with the supervisee. So the report went into some detail about, given the power differential between the Department of Corrections staff and the people that they supervise, and the possibility that the supervisees may return to incarceration, that sexual contact between any Department of Corrections staff and any supervisee should be a crime. That was the conclusion of the report. So this section is really comes directly from that recommendation from the DRM report, and it broadens the existing criminal prohibition on sexual exploitation of an inmate. But it does provide a carve out for existing relationships. So I'll just jump into the language here. So there are a few changes in subsection A here that just kind of reframe the conduct that isn't permitted. And it expands that prohibition, as I mentioned, on sexual conduct between department workers and people who are supervised by the department. So as you can see here, existing law provides that prohibits a correctional employee, contractor, or another person who's providing services to offenders on behalf of the department from engaging in a sexual act with an inmate in a correctional facility, or a parolee, probationer, or another person being supervised by the department in the community, if the person is being directly supervised by the Department of Corrections worker. And you can see that's the language that's struck through there. And so there's some new language. I'm going to scroll down so you can see it. So there's new language here that removes that limitation on that direct supervisory relationship in order for the conduct to be prohibited. And instead, it prohibits sexual conduct between a DOC worker and any offender who's being supervised by the department in the community, if the department worker knew or reasonably should have known that the offender was being supervised by the department. And then the language also specifically excludes from that prohibition any offender and department worker that were either married or parties to a civil union or otherwise engaged in a sexual relationship at the time of the sentencing for the offense for which the offender is being supervised by the department. So
Couldn't
the
it be
House,
worded
sorry,
engaged in a consensual sexual relationship?
that's a good catch there. That probably makes sense to add the word consensual.
Yeah.
Bryn,
Yes.
I have a question. So if you go back to page 11, subdivision 1, it says, shall not engage in a sexual act with a person who the employee, contractor, or other person providing services knows, and then first is confined to a correctional facility, or first of all, it doesn't seem like that sentence now follows grammatically. 2.
So the sentence follows from A, sub A above.
Okay,
So a correctional employee or other worker shall not engage in a sexual act with, and then you drop down to 2, any offender.
okay. Then my other question is, it says, oh, okay, so 1 is,
Yeah, so
one is complete in and of itself, and then 2 is a continuation of A.
that's right. Yes. And sub 1, I
Okay.
should have made this more clear. Sub 1 is really prohibiting conduct, all conduct between a DOC worker and a person who's incarcerated. And sub 2 is talking more specifically about people who are being supervised in the community. And so that's where you have that little bit more narrow prohibition on conduct.
Okay.
That includes the exception for people who are already engaged in a relationship.
I remember writing this statute. I remember Senator Nitka and I both commenting on when we did the original bill. And frankly, we were trying to carve out what I think has been more artfully carved out in the new language. That's the exact situation that we were trying to carve out. And it obviously left an opening.
May I ask Bryn a question?
Yep.
I'm just going back to what you were explaining here to Philip, and I don't know how to read this. I read A, shall not engage in a sexual act with, and then I read 1, a person who the employee, contractor, or other person providing service knows. And then there's no number, knows is confined to a correctional facility, or does that go, is that supposed to go, that 1 that was crossed off, is that supposed to go right behind knows? I don't know how to read that because
Yeah,
that sentence is just standing alone there.
I know it does look a little funny. It's because you're kind of collapsing. First of all, you're moving 1.
I think it would read better if we rewrote the entire 2.
I just don't understand where that sentence fits in because it has no number or no,
It
Anything.
follows, is confined to a correctional facility, follows the word knows on the line above it.
but shouldn't it be up there then?
Well, it's not because it's a subsection right now. This is like an operational issue. I'm sorry, I'm not explaining it very well. Because that subsection 1 is there right now, it has to be struck through and the language has to
Right.
stay there. We can't
Can
actually
we-
read it and move it around.
Yeah, I appreciate that. We can come back to this. when we mark
Okay,
it up, but,
sorry.
Yeah, no, it's fine. It might read better if we didn't have all that struck language in front of us. You know, if you read it in its total, where the employee, contractor, or other service provider knows or reasonably should have known the offender is being supervised by the department.
No, that's not where I'm confused. It's,
Yeah, I understand the confusion is subdivision 1, and I'd be glad to send you in an email what it will look like without all that struck through language or all
That'd be
the
helpful.
different lines.
Okay, that would be helpful.
thank you.
And why don't we go with Commissioner Baker? You can take that down now, Bryn. Thank you very much.
Good morning. For the record, my name is Jim Baker. I'm the interim commissioner of corrections. And I appreciate the committee taking up the section 1 and section 6 of this bill. And I guess section 1, I'll just comment on this. It is part of our continued effort to enhance, number 1, our hiring process, and number 2, accountability within our system. And it does follow, although not direct recommendations from the Downs Racklin Martin report, but it does follow recommendations that came out of the report. And so when the bill was being put together as a committee bill in House Corrections and Institutions, we were asking for this to happen, and through testimony realized that probably should take a step back and figure out how it would happen. Because, for example, polygraphs, you know, we are not included in the current legislation statute that allows to do pre-employment polygraphs. So our plan is to use polygraphs for pre-employment, as other justice-based organizations do. And then the drug testing was part of recommendations that came out of Secretary Smith's original report that went to the governor after the incident was brought out at Chittenden. And then we pursued it as part of the recommendations coming out of DRM. On section 6, I think, Senator, I just heard you say that you and Senator Nika remember probably dealing with the first time around the legislature. And we feel very strongly that there should not be the language of just direct supervision, that it should be if anybody's supervised, because it's our belief either for an incarcerated individual or an individual under supervision in the field, there is no ability for there to be clear consent. And it puts the folks that we're responsible for in a bad spot. And since I've been here, I've dealt with at least one case of a Department of Corrections employee who was charged criminally as a result of becoming involved with someone that was supervised, but it wasn't on that person's caseload. So we are supportive of changing that language and holding people accountable when they become involved. Understanding that, you know, if there's a reasonable belief that if they didn't know the person was being supervised, that's understandable, and we certainly don't want to get in the way of domestic relationships either. So we understand that.
Any questions? I'm going to start the question. I'm not objecting to the idea that the department could do a study of or do whatever, drug testing and polygraph. I'm just not sure the Justice Oversight Committee is the committee to do that study. having served on that committee for a long time, I do. Normally has not been our bailiwick, this type of thing. It's more I don't know, we'd have to research what other states do. I mean, it's a tremendous amount of work. Have
Yeah,
there been other studies of this, or do you know of any?
Within Vermont corrections or in other corrections organizations?
Nationally.
Yeah, I mean, we can easily find that out with surveying through the Corrections Leadership Association, which we're members of. And I understand your point here. I can't remember from House how it ended up joint justice would be the point. But, folks in the House felt a little uneasy about making that leap of just authorizing polygraphs in drug testing without some type of study.
I agree, but normally we would ask for example, the Department of State's attorneys, the Defender General, the Department of Corrections, the State Employees Association to, study the issue, come back with a report, perhaps to Joint Justice Oversight. But to assign Justice Oversight as the study committee. I mean, I don't know. Senator White,
We will be taking up this section in government operations also because it affects state employees. We will not be taking up necessarily section 6 because I think that is absolutely the jurisdiction of this committee. So, but we will be taking up section 1.
yeah, but because Justice Oversight is this committee,
Right.
is part of it, and I just want to, I'm fine, whatever, I'm just concerned about the ability of the Justice Oversight Committee to study an issue like this and come back with some kind of recommendation. It's not something I ever remember us doing.
Well, we may have some changes around that.
Senator, I think we can work with Senator White's committee and come up with a solution that resolves that issue for you. Because I understand exactly what you're saying.
I have to shut my window. It seems somebody's chipping down a tree in my front yard.
Well, that's good. It's raining here. Are there any further questions for Commissioner Baker? Jim, thanks very much for joining us. We appreciate it.
I do, not that I'm not interested in this bill, it's important to us, but I have to head to Bennington for my second shot, Senator. So
Congratulations. Good for you.
You should hear a loud scream coming from Southern Vermont College.
Southern Vermont. Yeah, I don't think I'll hear it today from here.
Yeah,
I got my windows closed.
Across the valley to your house, sir.
Good to see you.
Take care. Thank you.
Our next witness is John Campbell, the Executive Director of the Department of State's Attorneys and Sheriffs.
I think I'm here. Can you hear me?
We can hear you.
Good morning, Mr. Chair. Good to see you. John Campbell, Executive Director of State's Attorneys and Sheriffs. Not exactly sure why we're here, but we agree.
We're changing a criminal law.
No, I'm jesting, but I believe it's.
Oh, okay.
I was told to have.
Maybe you.
I just want to make sure, because I was told this had to deal with the, I believe it's section 6.
Yeah. Section 6 creates, updates the crime of sexual exploitation of a person under the supervision of the Department of Corrections.
Right.
It's a crime.
And we're happy to participate in this study. And I believe, let's see, hold on 1 second here. So this is why I'm missing Pepper, man, I'll tell you. It's,
you're not participating in a study. This section, you may be part of a study later on.
Yeah,
but our focus is on section 6, which is the crime of a person under the supervision of sexual exploitation by a correctional employee, contractor, or other person providing services to offenders to a person who's under the state supervision of the Department of Corrections.
I
and it updates that crime.
Yes, And I'm seeing that now, and I apologize. As you know, we've had a bit of a change, and
Yep.
I'm kind of like pinching into here at the last ninth inning here. We
You could be a Red Sox fan, and then that would you would be pinch hitting for the league leading team.
well, you do know that I'm a Yankees fan, but
I do.
also,
That's why I brought that up.
and the Marlins, but
Our next witness is a Red Sox fan.
I do have a Red Sox hat though. So
Good.
anyway, I remember when we had discussed some of this.
Yeah, you were on the committee, I think, when we wrote this.
Yes, exactly. And I think that the changes are good. I think that I apologize for looking not at you all, but I have another screen behind me that got the bill on it. And I think these are positive changes. And I think the Downs, Racklin, Martin, I heard Bryn mention that before as far as their report, which I think that is will also help the issues that we're trying to prevent here. So I'll just stand by for questions, I guess.
Are there any questions of John Campbell? John, thanks so much for joining us.
Thank you. I appreciate it.
Matt Valerio is our next witness.
I'll stand by the way, if there's any further questions.
Okay, good. Matt, are you there? There you are. Good morning.
I was taking off my Red Sox hat.
Good move.
Hard getting it off. Of course, everybody gave up after the first 3 games of the season. We're
Right.
just mailing in their cards. In any event, H 435, Section 6. I had concerns originally about how the bill as introduced was drafted, because it failed to take into account inadvertent relationships, because Vermont's a small state, and we know how you can meet people, you don't know where they work or what they do, and you can get into relationships and fail to take into account pre-existing relationships, all of which are actually constitutionally protected as a liberty interest, and under an old case that's more known for its support of contraception, Griswold versus Connecticut. But basically what Griswold said is that there are protected liberty interests in interpersonal relationships that the government should not interfere with. And I think that the amendment to the bill that is now in the bill as passed by the House accommodates those concerns, and we don't have any objection to it.
Good. Any questions from that? Yeah, Senator Bruce.
I do. Matt, so I hear what you're saying. I find myself stopping over the language on page 12, the last part of that amendment, which says married, parties to a civil union, or engaged in a sexual relationship at the time of sentencing for the offense for which they're being supervised. I'm just trying to remember anywhere else where it's a shield. It's basically a shield to have been in a sexual relationship with the person beforehand. It just seems a little odd to me. It's difficult to imagine how you would go about disproving that if I don't know. Whether somebody is married or in a civil union is very, very easy to prove in a court of law. It seems to me a weird area for us to get into. Well, if you were having some form of sex before X date, you're immunized under this statute. Any thought on that?
Only to the extent that as I described the constitutional liberty interest, that intimate relationships between people is a protected area under the Constitution. And so I think we have to tread very carefully around that. And this talks about it, and it's appropriate to put obviously consensual sexual relationship in there. I had some thoughts about the words engaged in an intimate relationship with somebody at the time of the offense, but that becomes even more vague and more difficult. Sometimes there are compromises when you're trying to tiptoe around a constitutional issue, and I think what this does is it recognizes that liberty interest, and I think there are, you can prove by testimony whether somebody was in a consensual sexual relationship, either by the testimony of either of the parties involved or their friends or relatives or the like. It's not perfect, but I think it does recognize the constitutional issue that's out there.
Okay, thanks.
Thank you. Any other questions from Matt? Thank you. David Scher, I'm sorry. Thank you, Matt. David Scher from the Attorney General's office is our next witness.
Thank you, Mr. Chair. Thank you, committee. For the record, David Scher, Assistant Attorney General with the Vermont Attorney General's office. Limiting my comments on the bill to Section 6, which we've been discussing. We support the addition, or I should say the amendment to this statute. As the committee likely knows, there have been some instances that would have been implicated had this statute been what it is proposed to be. We agree with Commissioner Baker's characterization that I don't want to mischaracterize what he said. I'll say our own characterization that relationships under these circumstances, I think, are inherently not consensual, given the very serious power differentials involved in somebody who's a supervisee of the Department of Corrections and somebody who's employed by the department. So we think that this is a reasonable expansion. We do approach expanding criminal liability with a presumption against doing so in most cases, but where there's a compelling need and where there's specific instances where we feel that very harmful behavior has been able to go forward without a mechanism to stop that, deter that, then we do support expansions, and we think that this falls into that category. This meets those tests, and for that reason, we do support it.
Great. Thank you. Any questions for David? David, thank you very much.
Thank you.
Ashley Messier is here. She has been working as an advocate for quite a while. Welcome, Ashley.
Morning.
Hi,
Thank you for having me. I
Nice
apologize.
to see you again. Ashley
Nice
and
to
I
see you
were
as
on
well.
a panel pre-COVID
We
on
were.
corrections. I think it was just before COVID,
Yep, the beginning of February.
beginning of February last year. Ashley,
Nice to see you
please
again.
introduce yourself and welcome to Senate Judiciary.
Great. I'm Ashley Messier. I'm the Executive Director of the Women's Justice and Freedom Initiative. Thank you for having me this morning. As for Section 6, we support the language we worked on over in the House, the amended language that we were just discussing around relationships that happened prior to sentencing. I think we were really concerned around, given how small our state is, if you think about how many folks the corrections department employs and then all of the contractors and service providers, right, that then work in addition to just corrections staff for folks who are incarcerated or under community supervision. I think we were trying to figure out a way to articulate that folks may have relationships with someone that may find themselves under the supervision of corrections. And so trying to find a way to articulate that there needed to be some pathway to protect those folks, sort of the middle ground between needing to build accountability, as you heard interim Commissioner Baker say, around the struggles we've had, but also how do we not further criminalize or further penalize folks who are doing the right thing, who are in consensual, appropriate relationships. And just given how many folks that is, both folks under supervision and then the way that employment looks for corrections and all of its contractors and outside service providers. So we support the language as it's written in the current version.
Questions for Ashley? Thank you very much. Senator Benning had to leave for another meeting, unfortunately. He apologizes for missing your testimony.
Thank you very much.
Thank you. Bryn, I've got a question about how broad other person providing services is. Another person providing services could be a local Turning Point Club, local mental health center, the local school. That we have what's called the tutorial center, which is adult basic education. Just thinking of all the community groups who might provide services.
I would just point out that it is qualified that they have to be providing services on behalf of the Department of Corrections. So that does limit it to some extent.
So they have to be
providing services on behalf to offenders on behalf of the Department of Corrections. So I imagine they have to be in some sort of formal relationship with the department in order to be covered.
Senator White.
Would that, it just dawned on me that if we have transitional housing for people coming out of prison, would that also cover whatever organization or agency is providing the housing?
I imagine
So.
if they're again, they have to be providing those services on behalf of the department. So if they are in a formal relationship with the department where they are providing services to a person who is under the supervision of the department on behalf of the department, then that would they would be included. But
so a landlord or a housing agency that has a contract for transitional housing would also be covered. All their employees here would be covered under this.
As long as the person was still under the supervision of the department and they were providing those services on behalf of the department. So the commissioner may be better able to talk about those relationships than I am, the details of those relationships.
Yeah, Jim is back on. Thank you,
Yeah,
Jim. I don't want to hold you up and getting.
No, I got a couple
the
more minutes.
hospital. Okay.
I'm glad I stayed on. So Senator White, it would include in our mind, our relationships with transitional housing. Because from our standpoint, if we transition someone into housing and we have a contract with them, and that person knows that their ability to remain in housing is dependent on the person that's running the program, that's in my mind not much different than a probation and parole officer who's supervising. They're holding power, a differential in power over an individual. And I think it's very difficult for a clear consensual relationship to develop when you have that power, that type of power differential.
So just, I'm trying to figure out how far this would extend. If we have a housing organization that has a contract with you to provide transitional housing, and the housing organization has 45 employees, and would the maintenance person who works for the housing organization be covered under this? Because there really isn't a power relationship there, but they still would be covered, right?
It's a good point. I guess from a legal standpoint, I'm trying to tell you what our intent was when the
Right.
conversations came up, but I think this is a valid point. I guess I don't have a response to that. I have to think that through.
Yeah.
But
Well, I get,
if
there are
someone's housing depends on that, they feel like their housing depends on entering into a relationship, I think that's a problem.
Yeah.
and I think there are, areas of the state where the Department of Corrections has contract with the designated agency, for example. And how far in, designated agencies can have 100 employees. How far in does this cover? I think that those are good questions. But they're part of current law. All right?
Yes, they are, that is current law.
Correct.
And I guess I would just point out that the person has to be providing services to offenders,
The person itself, not the organization necessarily.
right?
Okay, that's helpful.
Senator, I hate to skip out, but I do need to leave, so I
Well, good luck. And I doubt we'll hear much screaming. And but
What are
good
you
luck with
doing?
the shot.
Getting a
He's
shot.
getting a thing called the COVID shot.
Oh, okay.
So Senator, I'm getting my second shot so I can get furloughed, okay?
Yeah, it'll be nice to be able to walk. Actually, I've had it, and although I still haven't really gone anywhere,
I know.
it's comfortable to be able to go
Right.
places and not
Right.
feel like you're putting your life in danger.
And it's amazing work that the folks are doing that are doing these vaccines. It's incredible.
It's incredible down at Southern Vermont College.
Incredible.
They're
So
doing it.
thank you for taking this up, and
You're welcome. Thank
we'll
you.
talk soon. Thank you.
Thank you.
Committee, and for Bryn, I think the only change that I have would be adding the word consensual on behalf of the committee, and then when Senator White's Government Operations Committee takes it up. I don't necessarily need to have the bill sent here. You can just either add it on as an amendment from me, or your committee can put it in as an amendment. I don't know how you want to do that, Senator White.
Well, it might end up being a strike all anyway. We don't know. So when we go through it, Bryn will just bring that word, and I'll bring that word to the committee, and we'll.
Are there any other changes to section 6 that anybody wants to consider?
I think there still is a concern in my mind about, Bryn, you had mentioned that this was the law already. I'm thinking about the gardener who works for the housing project. Is his work providing a service to the persons living there? Or just to the?
I imagine it would be a question if this were to be a litigation before a court, whether a gardener would be considered to be providing services to offenders that are being supervised by the department on behalf of the department. That would be a question for the court to consider. I suspect that the more tangential you get to the services provided to actual offenders, the less likely it would be that a court would find that relationship problematic.
Hopefully. Well, okay, thanks.
Now, going back to section 1. I think it is to some extent, if the Government Operations Committee desires to keep section 1 in, I would hope that they would find some other group to study this. A report certainly could come to Justice Oversight, but asking the Justice Oversight Committee to directly study this subject is beyond remember us trying to tackle this type of issue. Bryn has been basically the staff assigned to justice oversight. I would think that somebody else in the council would have more experience in that area as well.
Yep, I can't remember the committee going into this kind of area in the past.
All right.
Um,
Anything else? I don't, maybe we'll get out early today. Pretend it's Friday.
Always nice.
Yeah, at first I thought, oh, we're gonna make it 11:25 to get out for the floor at 11:30, but then I realized